Okay, hello to everyone. Let's start the meeting today. Thank you. Good morning to everyone. Thank you very much for joining us today. Special thanks to those at the other side of the Atlantic who had to wake up very early this morning. Thank you very much. Next time we will try to schedule the session at the afternoon, so to make it easier. Thank you very much. So today the seminar is entitled Competition Law and Policy in Digital Markets, the Direction of Travel. This is the last seminar of a series of seminars and workshops called Rethinking Competition Regulation in Light of Digital Revolution, La Competencia en l'Era Digital, which have been carried out by the Catalan Competition Authority with the collaboration of Palau Macaya and La Caixa Foundation during this year 2020. You can find contributions and videos of all these sessions on webpage. Okay. The initial idea of organizing this series of seminars and workshops probably arose back in 2017 from the technical debate that we had internally in relation to the fine of 2.45 million euros imposed to Google by the European Commission in the Google Shopping case. Since then, I would say, or honestly, probably a little bit before, the notion, my opinion is that the notion of market power and dominant position in digital markets is a topic that has been under consideration for many competition authorities. As an example, we have nowadays the CMA talking about the strategic market status and the Bundeskartellamt talking about paramount significance for competition across markets as possible definitions to overcome the problem of defining what is a dominant position in digital markets. Additionally, we have seen last week how the European Commission announced a statement of objections for considering that the use of non-public independent seller data acquired by Amazon's marketplace to benefit its retail services could breach Article 102 of the TFUE. But not only is the notion of dominant position in digital markets being re-evaluated by competition authorities, but also other aspects of the competition policy. New forms of anti-competitive agreements and mergers are also under consideration or discussion. Moreover, discussions go even further, considering fields that traditionally were not related with competition policy, such as the use of personal data and privacy, but that relate to competition when these issues involve big tech companies. My idea is that, or my opinion is that the main rationale behind all this discussion is the need to determine whether or not the big amount of data and the big processing capacity that big tech companies amass is a problem in terms of competition and general welfare or not, or in other words, to determine whether or not do we have a social dilemma, as it is talk these days. I'm very glad today because we have Professor Pinar Agman with us, and she will put some light on these topics. She is professor of competition law and director of the Center for Business Law and Practice at the University of Leeds, and she has a brilliant and successful curriculum vitae. After the speech, I'm also happy to announce that we have a first row of 4 attendees: Shane Tews, visiting fellow at the American Enterprise Institute; Daniel Lyons, professor at the Boston College Law School; Thibault Schreppel, assistant professor at the Utrecht University School of Law; and Sandeep Bayesian, legal director at the Open Markets Institute. They will have 5 minutes each after Pinar's speech in order to enrich the debate with questions and comments, and then we'll have some debate. So with no more introduction, I'll give the floor to Pinar. So Pinar, the floor is yours. Thank you very much to everyone.
Thank you, Mark. Let me try to share this screen first and see if this works. Does that work? Great. Thank you, Mark, and many thanks to the Catalan Competition Authority for this invitation. It's a real honor to be able to join you today, and I'm sorry we couldn't do this in person in Barcelona. I'd like to thank also the discussants who have agreed to join us today, particularly those of us who are joining us from the United States. It's a very early start for them. So my research over the last few years has focused on competition in digital markets. And some of my research has been looking at certain practices and types of conduct in certain markets and some more fundamental questions. And other aspects of my research have also focused on the more general question of essentially where are we headed towards in the context of adopting competition law and policy to the challenges of digital markets. In that second category, I would put a piece I prepared for the World Economic Forum, which was published as a white paper for the World Economic Forum. And that paper was the outcome of several rounds of consultations with stakeholders from all sides of the debate. And it tried to really put forward some suggestions for the way forward. So towards the end of my talk, I'm going to refer to some of those insights. Now, before I say anything about competition law and policy, I think first we have to talk a bit about the context. And this is the context in which we're having this debate. And I think many of us will agree that digitalization and globalization have essentially transformed the way we live, the way we work, the way we communicate, the way we trade, the way we express our opinions, the way we invest, innovate, and so on. And there's barely an aspect of our personal, social, professional, and economic lives that has not been touched by digitalization. And to just try to explain the degree to which this has happened over the course of the last 20, 30 years. So in the late 1980s, less than 1% of the world's information was digitized. By the time we got to 2014, analysts suggest that more than 99% of the world's information was digitized. And it seems that we're actually at the beginning of essentially a digital data creation explosion, as it were. So in 2019, for example, the World Economic Forum predicted that by this year, by 2020, the amount of data in the world would reach 44 zettabytes. So the infographic I have on the screen, which is from Statista, suggests that this would be 47 zettabytes by 2020. And just to try to explain to you what that is, and I'll save you from having to count how many zeros there are in that slides. There are 21 zeros next to 44. So again, to put it in context, we are in a context where there are potentially 40 times more bytes than stars observable in the universe. And if you look at the infographic there, this is not even the beginning, because in 10 and 15 years' time, there's going to be even a bigger explosion in the amount of data we are creating. And multi-sided digital platforms, on which my talk will focus on today, have been really driving much of this digital transformation. And I think you'll probably agree with me that there have been five particular platforms that have been key players in this digital transformation. And those five are Amazon, Apple, Facebook, Google, and Microsoft, whose combined valuation together is around $6 trillion at the moment, which is around a quarter of the entire Standard & Poor's 500 index. And the Standard & Poor's 500 index is an index of the 500 largest publicly listed corporations in the United States. So some more facts. At the moment, again, 7 out of 10 of the world's most valuable companies are tech companies operating online platforms. So the five are the five I just mentioned, and the other two are the two Chinese tech giants, as they're generally known. And this trend is not going to, reverse itself, I don't think. So digital is pervasive and it will only grow. So pre-COVID, analysts had predicted that by 2025, 25% of the entire economy may be digitalized. So I think there are two things to note here. The first one is that digital will only grow. And the other thing is that if in the not too distant future, a quarter of the entire economy is going to be somewhat digitalized, then it's perhaps not very fruitful to think of digital markets or digital economy, because these concepts are likely to be redundant in the not too distant future as digital spreads across the economy and throughout the society. Now, later on, I will talk a little bit about the distinctions between different online platforms and their particular features that matter from a competition law and policy perspective. But first, I'd like to say a few things about their common features. And for the purposes of this talk, when I talk about a digital platform or an online platform, I refer to a digital service that facilitates interactions between two or more distinct but interdependent sets of users who interact through the service via the internet. So this is the definition of a platform that was provided by the OECD a few years ago. And perhaps conceptually, the easiest way to think about an online platform is to think of it as a matchmaker. So a platform is essentially an intermediary, a matchmaker that brings two parties together, and both of these parties have something valuable to one another that they would like to exchange, and essentially the intermediary facilitates this exchange and reduces the transaction cost because it makes a match. And platforms come in different sizes and different shapes, but they share some important economic features. First of all, the activity in which they're engaged can be seen as the activity of orchestrating value creation. So they create value, they orchestrate the creation of value by bringing together different types of users. This is different to a traditional, let's say, seller or a manufacturer who might buy input, raw material, and produce something and then pass it on to wholesalers who pass it on to retailers to sell it on. Here, the value creation does not come from the platform producing one thing in particular as such, but the value creation comes from the fact that the platforms orchestrate others creating value. And again, it's inherent in the definition of a platform that they are multi-sided. So they bring different types of users together, and they will need at least two sides. So it could be, for example, the users of a social network and advertisers, or it could be content providers, users, advertisers, and so on. They're always multi-sided. And this relates to also the fact that there are network effects involved in practically all platform markets. So network effects can be thought of as essentially in a scenario where you will think about which platform to join, and this might be a social network or it might be another type of platform. And generally on the user side, let's say, the more of your friends are on a given platform, the more likely you are going to join that platform because you wouldn't want to be alone on a social media network. And once there's a significant number of users on one side, there will be significant numbers of users joining from the other side of the platform. So on the other side of a social media platform, it could be the advertisers. And network effects are not easy to attain. Obviously, there's a chicken and egg problem. Which side do you bring on board first? And once you bring on that side, how do you bring on the other side on board? And essentially, for most platforms, once they attain the network effects, the better it gets, the better it gets. The more friends join, let's say, a social network, the more advertisers will come to advertise to them. And then you have the positive feedback loops. The more investment the platform gets from the advertisers, the more it can invest in the platform, and the more users that investment will bring to the platform. So essentially, there's a snowball effect, a virtuous cycle once the network effects actually work. And again, perhaps unlike traditional markets and platform markets, price structure rather than price level is quite important. And that's because the platform has to solve the puzzle of which side of users it can bring on board first which will then bring on board the other side of users to the platform. And there it has to come up with a price structure which will facilitate this. And it's not so much about price levels anymore, but it's about the price structure, in that, for example, one side of the platform may have to receive this platform service at zero price for free, so that the other side can be attracted after a critical mass is reached on one side of the platform. And again, two other features of platform markets: economies of scale and economies of scope, including economies of scope in data, matter quite a lot. So generally, these markets have high initial costs, many of which may be sunk, but then it's relatively cheap to essentially bring in more users once the initial investment is sunk in the platform. And economies of scope in data in particular matter here, because it's not necessarily the case that the more data a platform has, the better its predictions become in one aspect or on one data variable, but there are economies of scope in data, in that if a platform knows not only where I am, but also what I am likely to buy next or where I am likely to go next, then those different types of variables relating to, let's say, their set of users will essentially create an advantage for platforms who can achieve the economies of scope. Now, Mark raised the question whether we are facing a social dilemma. And I think the easy and quick answer to that question is yes. And sort of taking a bird's eye view to how I see what's going on in platform markets and in the digital economy more generally, I think there is what I can see as a clear yin-yang situation, where there are at least two strongly opposed features or forces. And I'm using these concepts as shorthand. So on the one hand, we may put together essentially all the features that we can call as aspects of surveillance capitalism. And this is a term coined by Shoshana Zuboff. And on the other hand, I think we have aspects in these markets, all of which we can bring together under the umbrella of what we can call democratization of markets. And this is how OECD defined these markets in one of its studies a few years ago. So essentially, the way I see it, it's all about on the one hand and on the other hand when it comes to platform markets. So I'll say a little bit about what I see on which hand next. So I'll start with the benefits, and these can be put together as essentially expressing the idea that platforms, from an economic point of view for a start, but from other perspectives as well, have democratized markets. And how have they done that? So there are different features that fall in that category as far as I'm concerned. First of all, I think we can hopefully all agree that platforms have created an expansion in the economy in terms of resources. So they have utilized previously dormant resources through introducing new types of transactions, services, and sometimes entirely new markets. So your spare bedroom, which was a dormant resource, can now earn you revenue, or your spare time, previously, which wasn't of any value in terms of the economic output, can now actually be an output or an input into the economy. And I think in general, this has resulted in increasing the size of the pie. And platforms have also lowered transaction costs. So transactions which previously were either not possible because they were prohibitively expensive or logistically not possible, particularly I'm thinking of e-commerce here, have become possible thanks to the facilitation of the intermediation of platforms. Platforms have also created new employment opportunities. And again, perhaps we don't always talk about this, but this increase in economic employment opportunities has also expanded the workforce in ways which have enabled previously underrepresented segments of the society to take part in the economic life of society too. So one study shows, for example, that 9 out of 10 drivers driving for Uber in New York City are immigrants. And so they're really, when we look at these markets, nothing is really unidimensional. There's always more than one dimension to whichever feature we're looking at. And that's why I think this is really a yin and yang. And they have increased convenience, personalized products and services. rapid and varied delivery options, to the point that I think now competing on your delivery options is an area in which competition takes place, which perhaps previously didn't occur. In terms of democratization of markets, one particular feature here is that platforms as intermediaries have facilitated and enabled small and medium-sized enterprises from all around the world to be able to essentially open up the global markets and to make sales, which were not previously possible. And again, last but not least, they have made it easier to connect with others. They've increased communication options. And again, perhaps in the Western world, we tend to think that all that they have done is to enable us to exchange, cat videos with one another. But in other parts of the world, these platforms have also actually facilitated people to communicate with one another in the organization of protest, expressing their democratic rights, and so on. And one feature that I'd like to mention before I move on to the other side, the other hand, is that the value of the services provided by platforms is generally systematically disregarded in the measures of the economy, because the measures of the economy, the one measure we use most commonly is that of GDP, and GDP only counts something in if it's got a price tag. But we know that many of these services are provided for free, so they're generally therefore systematically disregarded when we're measuring the value of economic activity. One estimate from a few years ago is that this GDP addition to the GDP in the US alone in 1 year would be around over $100 billion. Now, on the other hand, I think the list of concerns is almost just as long. And here the proposition is that we are possibly on course for a new type of serfdom, where we are actually essentially the raw material. Us as human beings, are the raw material for the surveillance capitalists' profits. And I've sort of brought together numerous concerns under this heading, because these are somehow aspects of that one big concern. Essentially, what's happening with our data and what are we being used for if we are raw material here. And this list includes fake news, misinformation, disinformation, privacy violations, mental health, election meddling, child protection, serious child protection concerns, hate speech, and so on. So the list goes on. And as I'm sure you'll appreciate, not all of these, in fact, not many of these are necessarily competition problems or problems that could be resolved through just using competition law or policy. In the market context, though, one particular concern has been that ineffective competition enforcement is essentially what led to the emergence of these tech giants. And these tech giants now have insurmountable market power. And with increased market concentration that comes from that market power, we see less innovation, lower quality of services and products, lower wages, and so on. And in some ways, actually, these features feed into those other concerns, which perhaps to a degree result from the essentially rise of market concentration and market power. There have been several suggestions in this context following on from these concerns, and these include, again, a long list, and I'll come to some of these later on, but just to sort of give a broad picture of what have been suggested, one suggestion is that these gatekeepers, the particularly big tech companies, should be broken up, or they should be regulated. They should be banned from selling on their platform. They should be banned from giving their services default status. They should be banned from favoring their own products or services. They should be banned from entering into exclusivity agreements. They should be restrained in their mergers and acquisitions activity. They should be subjected to reversals of burden of proof. And at one point, it was also suggested in the UK that they should actually be nationalized. Now, let's sort of steer towards more competition law then. In the context of competition law and policy, given all that background and given all that context, it's quite, I think, easy to see that there are certain features of the platform business model that pose some significant challenges when it comes to enforcing the law for competition authorities. And I'd like to talk a little bit about what these challenges are. And this is not even necessarily an exhaustive list either. So I think the first challenge starts from the fact that these platform services are generally provided for free to consumers. And as those of you who are competition specialists will know, any competition analysis, particularly in the area of abuse of dominance or monopolization, assessing market power, will generally start from defining the relevant market, because we have to establish over which relevant market this company in question has market power. And the current tools that we have for defining the relevant market are all based on there being a price. Without there being a price, we don't really have a starting point as such in order to define what the relevant market is. And the other issue we have in trying to define markets in markets with platforms is that because of the way platforms operate, and essentially because of that pervasive digitalization of the economy, it's also not so easy to be able to distinguish between what are online markets and what are offline markets. So are, for example, offline and online retailers in the same relevant market, or are they in different markets? And although these sound like perhaps trivial or easy questions, when it comes to applying the law, these are the first hurdles that we need to get over. And I don't think we have answers to these. And platforms not only provide many of these services for free, they also don't compete on one product or one service. So they engage in so-called ecosystem competition. Any of the platforms that I have named so far have multiple types of products or services or features. And this poses a further challenge in terms of establishing market share, which we normally use as a starting point to establish dominance. Because if the platforms are all engaged in ecosystem competition, what parts of this ecosystem are in the same market, or even if they're not in the same market, what parts of the ecosystem are relevant for assessing the effects of competition later down the line? As I said, these are all multi-sided markets with network effects, which means that it's quite difficult to get a platform to become successful because there is the chicken and egg problem, and then there is the further problem of monetization once the user sides are on board. And what generally happens in these markets is that because of strong network effects, competition normally takes place for the entire market rather than in one part of the market for market share. So generally the platform markets in the end either tend towards monopoly for these features or towards oligopolistic market structures. And this throws challenges for, first of all, measuring market power, because when you're competing for the entire market, and perhaps the only way you are going to succeed as a platform is to have the entire market, then the traditional criterion we use for establishing market power, which is market shares, is no longer meaningful, because without the market power, without the market share, which is almost the entire market, the business model will never succeed. So whenever we're looking at a successful platform model, we may be looking at very high levels of market share. So market shares are no longer as meaningful as in traditional sectors to establish market power. The other issue here is that these markets, if we look at perhaps markets as in, let's say, search engines or social media, we might see that there will only be a few competitors in that market. But also if we take a bird's eye view, we also see that overall the digital platform economy has an oligopolistic market structure where you have 4 to 5 firms. And again, those of you who are specialists in competition economics will, I hope, agree that actually our understanding, both from a legal and from an economic perspective of oligopolistic markets, is probably far behind our understanding of many different types of market structures. So this is a further challenge, because it's much harder to be able to establish in an oligopolistic market structure whether the companies are actually competing or not than, let's say, in other market structures. So a further effect of network effects is that, as I said, this is a virtuous cycle when the platform manages to succeed. But that also makes it very difficult to contest these markets. And these markets, therefore, can tip. So one company or one platform can essentially take over the entire market because the market tips towards that one provider. Most often, this is the one with the first mover advantage. And essentially, the success of one platform is the entry barrier of another. So barriers to entry are almost natural results of the network effects in these markets. Platforms also have a tendency to move fast and break things, and this is perhaps in the nature of these markets. They're dynamic markets, and that contrasts quite starkly to what happens in competition enforcement. Competition enforcement necessarily takes a long time. And I think one of the main concerns in these markets is the time lag, essentially, between an authority being able to intervene in the markets and the markets having tipped or having essentially moved on. And just three sort of final legal sort of concrete issues that we have also seen in recent times in these markets. One of them has to do with, again, network effects, where because platforms start small and while they're trying to attain network effects, there's generally at that point not even any monetization taking place, because the platform has to figure out how to monetize the network effects at a later stage, unlike traditional, again, market structures and businesses. Particularly in the area of merger control, this has led to legitimate questions being raised around whether merger control has to take a different shape when it comes to digital technology markets. And that is because, especially when the merger is between an incumbent and a startup, where the essentially incumbent may be taking over a startup which on paper doesn't really have any revenue and is rather small, although this may not be caught in the net of merger control. Perhaps it might be time to reconsider the net, because there have arguably been acquisitions in the past where the competitive value of that startup has been underestimated because the traditional merger control rules simply don't account for platform markets, essentially, and their features. And I've done some work also on some more fundamental questions. So, for example, from a legal perspective, we don't quite actually know what is a platform. And for competition purposes, this is a rather, again, serious problem, a serious hurdle, let's say. I'll call this the platform gap, because at least in European competition law, we have a characterization of certain relationships as agency. And if that characterization holds, then European competition law doesn't apply to anti-competitive agreements between parties who are in an agency relationship. Now, if we think of platforms as intermediaries, there are different ways in which we can define them for the purposes of competition law. I think they're agents, but another commentator or an authority may think that the same platform, which is an intermediary between different suppliers, may also come to the conclusion that they're actually a cartel. And if we add the gig economy here and the platforms that are in the gig economy, then we also have to consider another possible relationship, which could be that of employment. And all of these characterizations are mutually exclusive. So there are some really basic and fundamental questions that we haven't yet resolved in this space. And finally, again, because of the way platforms intermediate transactions and bring different parties together to engage in an economic activity, and again, because they are active in so many different market levels and so many different markets, we also see that the traditional distinction we make in competition law, which is normally between vertical and horizontal restraints and interbrand and intrabrand competition, again, are not necessarily applicable in these markets, because we can no longer easily distinguish what is a transaction or what is an activity that affects competitors and what's an activity that takes place vertically between complements. So there are many, many challenges. And as I said, this is not even probably the full list. So this has led to, as I'm sure you know, many, many reports being issued on the topic, and many, many proposals have been made. And I've tried to sort of put them here on a spectrum, as it were. And this isn't an exclusive list of what has been proposed. And sometimes the more you move towards one end of the spectrum, the more you will have all of these being proposed on top of one another. But just to sort of present the main suggestions out there. So at the one end of the spectrum, you will have the option of doing nothing. And at the end of the spectrum, the other end of the spectrum, you will have the option of essentially breaking them up. So breaking them up here generally refers to the big tech, either the 4 or the 5 that I have mentioned before. I think both ends of the spectrum are not that particularly, how shall I say it, well informed. And I don't think either end of the spectrum is going to be where we will end either. In the middle, really, you have several options. So one option is to use existing competition law rules, but then also, for example, establish digital or technology units within a competition authority or elsewhere, so that these markets, digital markets, are sort of under, not necessarily supervision, but I suppose under ongoing scrutiny. Added to that is the option that you would also have in jurisdictions where this doesn't exist, the ability to conduct market investigations. And I call this market investigations because I'm based in the UK, and the European Commission currently calls this a new competition tool, and there are consultations taking place in relation to that. And by market investigations, I refer to enforcement tools, essentially, that would enable a competition authority to essentially carry out a market study of an entire market where it suspects that there are features of that market that mean that competition is not working effectively on those markets. But that market investigation tool would also enable the competition authority to intervene with remedies at the end of that market investigation without necessarily, and in fact, without finding an infringement on any one party's behalf. So these are not infringement investigations, and they're not directed towards one or two companies necessarily, but they're essentially looking at an entire market. So this is being debated in the EU, for example, and there's also a discussion around whether there should be separate codes of conduct that apply to platforms that are known as gatekeepers or those with strategic market status. And the idea with a code of conduct is that it's a more flexible tool than having perhaps ex-ante regulations. Now, ex-ante regulations are also being debated alongside the possibility of having specialist digital regulators. And in the EU at the moment, there is again another consultation on whether we should have an ex-ante list of blacklisted clauses, grey-listed clauses, or whitelisted clauses that would apply to gatekeepers. Further suggestions include introducing presumptions of illegality for certain practices of platforms. This can be in the merger control context, but I think this has been suggested also for broader types of practices that have to do with market power more generally, and not just in the merger context. And again, there are suggestions that in certain cases, the burden of proof should also be reversed and put on the platform with market power to prove that its practices do not violate competition law or do not produce anti-competitive effects on the market. So there's really a long list of options on sort of a wide range of spectrum. Now, given also how complex and perhaps how politicized this debate has become, I think in terms of going forward, of all these options, whatever option we go for, I think authorities and policymakers have to be guided by the evidence and only the evidence. And by evidence, we have to actually mean actual evidence. I mean that competition authorities have to get their hands dirty. And it's the competition authorities or similar enforcers who have to actually gather the evidence from these markets and be guided by that. So evidence, as far as I'm concerned, doesn't include reports from the trade press. Evidence doesn't include anecdotal evidence. This has to be evidence that are collected as evidence through studies of markets. And some authorities are undertaking these studies. So, for example, the CMA has done that. The Australian authority has done that. Others are doing that. But this is the authority having to actually collect the evidence itself, whilst being open to the idea that once it collects the evidence, it may change its mind, as has happened, for example, in the case of, again, the Australian authority, which did change its mind regarding something to do with search defaults after having gathered the evidence. And the reason evidence is so important here is because there are features of the features of digital markets that deserve attention are possibly also the features that makes these markets more efficient by yielding better outcomes for consumers. And therefore, there really has to be essentially a cost-benefit analysis. And as far as, again, I'm concerned, any changes to existing frameworks would need to be guided by first an established theory, then the necessary empirical base, so the evidence, and then a cost-benefit analysis. So in going forward in that space, I'd like to raise 3 questions, or I'd like to suggest that there are 3 questions that I think we need to be bearing in mind, particularly when we're actually changing established frameworks to move on to new frameworks. The first one has to do with regulation and ex-ante regulation and how that will interplay with competition law, with existing competition law. The reason I ask this first question is because if we look at experience in general with ex-ante regulation, and when we have used in the past ex-ante economic regulation, we see that we've generally used this in cases where we know that competition doesn't work, we know that competition will not work, competition has failed to work, and these are generally natural monopolies where we use ex-ante regulation to impose certain terms and conditions with which we try to essentially substitute competition. Now, in the current debate, we're talking about using regulation, ex-ante regulation, in a rather different context. And in the current debate, we're talking about using ex-ante regulation that will not be a substitute to competition, but that will complement competition. And the question is, do we yet have a regulatory theory that can inform this type of use of ex-ante regulation? The second question is, again, when we're thinking about how to change frameworks, is there sufficient empirical data on the relevant markets and on the behavior of firms and consumers on those markets that can enable a cost-benefit analysis of different types of outcomes? So the cost and benefit analysis of taking a given action or not taking that given action. So have we got enough information? Have the policymakers got enough information to be able to engage in that cost-benefit analysis? I assume the answer to that depends on the market that they're looking at and will have to change from market to market. And again, that requires having collected evidence in the first place. And finally, the last question that I think we should be guided by is, are the policymakers clear about what the ultimate goal is? And does their expressed goal add up when we compare that against the evidence they put forward to justify their actions or to justify their lack of actions? And I don't really want to open the can of worms here, which is that of what is the objective of competition law. But I think this is a discussion that has to be had. And in the UK and in Europe, in the European Union, this is generally being seen as the essentially making markets work well for consumers, as the OFT used to put it. So is the goal here to make markets work well for consumers, or do we have other goals? In which case, I think we need to have an open debate about what those other goals are and whether they trump the interests of consumers and making markets work well for consumers. Now, going forward, I think there are some emerging insights that can inform competition authorities' practice and policymakers. And one of the main insights here that I mentioned came out of the white paper for the World Economic Forum was that when it comes to platforms, as much as this sounds like a cliche, one size really does not fit all. Platforms come in very different types and shapes and sizes. And I think if we are going to try to bundle platforms together, we have to come up with ways of doing this where it's more meaningful than saying these are all gatekeeper platforms, so we'll subject all of them to this set of rules. And the reason I say that is because a gatekeeper platform on the online travel agent market, let's say, is very different to a gatekeeper platform on the search engine market. And they operate on entirely different business models, and the rules that we make that we hope would be applicable to all of them is not likely to be applicable to all of them because of the different features of their operations. So I think bearing in mind that we can't just bundle all sorts of different types of platforms together and expect that the same set of rules will apply to all of them is not particularly helpful. And that has to be, again, guided by the evidence on the markets and an in-depth understanding of the business models involved. Now, I think given the limitations on the resources of competition authorities and policymakers, it might also make sense to prioritize those areas where market-driven solutions are unlikely. So there are some features and some aspects of competition not necessarily working as well as it should on these markets that market providers may provide solutions to. The Australian authority, again, has identified this, for example, in the context of advertising and transparency, where through its market study, it observed that the lack of transparency in the advertising model is being to some degree essentially not necessarily compensated for, but is being catered for by market-driven solutions, essentially third-party intermediaries trying to come over the lack of transparency in these markets. And I think another useful idea might be to try to learn not just from necessarily mistakes or where things might have gone wrong, but also from occasions where things have actually gone well. So I know that competition authorities occasionally carry out merger retrospectives, and I know that these are also very resource intense, and these don't happen perhaps as often as they should. But I don't know whether, for example, competition authorities also look at also carry out entry retrospectives or disruption retrospectives. And the reason I think this may be useful is that there has been entry into some markets which were previously thought to be markets that have tipped. So an example is Spotify. iTunes was seen as having completely taken over that market, but Spotify managed to enter and dislodge iTunes. So that's just one example. But I think it would be insightful to look at what made Spotify, what were the features of the Spotify business model or those markets that enabled Spotify to successfully enter that market and dislodge an incumbent. And there are other examples too. And I think we need to be able to looking at these to gather again empirical evidence from those markets to see what are the features of these markets that competition authorities can then try to enhance given their tools that they have. Again, follow the money and follow the data. So these platforms have perhaps different features to more traditional sectors and markets, but they are still in this for making money, and generally that money is made through the data. So follow the money and follow the data. Perhaps many of the questions can actually be answered by trying to find out how this all fits together. So these are multi-sided markets, and on different sides that we look at as sort of a complex unit, we will see that exchanges of data happen in return for exchanges of money. So in some ways, some aspects of this may not be that complex, but to be able to do that, the competition authorities themselves have to have the tools. They have to have the technological tools and the expertise to go after the data. And I think it's essential that going forward, competition authorities will need to have computer scientists on board if they don't have them already. And having said that, that doesn't mean that we should have digital authorities, because if digital is as pervasive as we think it is, then a digital authority will not be so meaningful, because practically all aspects of our economic and social lives will be to a degree digitalized. Another I suppose, aspect that I don't see many authorities paying attention to is digital literacy. So another fact here, which is that by 2030, it's predicted that 90% of the entire global world population older than 6 will be online. I find that fact quite scary, I have to say, because I've recently carried out an empirical study, and I don't want to spoil the results of that because I haven't yet published it, but this was a large empirical survey of asking over 10,000 consumers across 10 markets how much they understand about what's actually happening let's say when they go and search for something on a search engine. And again, I don't want to give away the results, but I think you'd be shocked when you find out the level of misinformation. It's not necessarily even misinformation, it's simply the level of unawareness of how things work on the internet. And again, as far as I know, the Australian authority here is the only one who actually spent time in that market study explaining how important it is that we have to up the game when it comes to digital literacy. Consumers, starting from children, have to understand how these platforms work, how these markets work. And unless consumers are educated, unless consumers are empowered through that education, I don't think competition will, in the long run, work in these markets. So talking about consumers and consumer protection, again, another insight that came out of that consultation in the context of the World Economic Forum white paper was that consumer protection issues and competition concerns on these markets are often very closely intertwined. And it seems to make sense that these powers, enforcement powers in consumer protection and competition, are concentrated in one and the same authority. And if they're not concentrated in the same authority, there has to be at least formal mechanisms of these two different types of authorities communicating and liaising with one another in these cases. Another insight I would suggest is that competition authorities have to be looking towards what I would call the next big thing markets. So the markets that have not tipped, and looking at ways to see if they can take action that would reduce the barriers to entry by either stimulating entry or by stimulating multi-homing. Again, this seems like a fairly straightforward, I suppose, solution, but of course they need to be having those markets or the digital units in force to be able to essentially, I suppose, monitor these markets to see what may be the next big thing. Where is the next wave of innovation going to come from? Where is it that we need to be looking at preserving competition? I think I said quite a bit about regulation, and this is what I sort of think at the moment about regulation. I think it's quite clear that certain aspects of competition on digital markets and also certain non-competition aspects of digital markets do require regulation. The question is, what should that regulation look like? And here I have picked some that I think are no-brainers. So there is little sort of I can think of few reasons for which we shouldn't do some of these. And that should be, I think if you engage in the cost-benefit analysis there, you will see that almost certainly the benefits of adopting some of these are going to be higher than the cost. The first one is market investigations. So I never understood why at the EU level, for example, we don't have the ability to do these market investigations. Looking at CMA's reports, for example, we can see that the CMA has saved British consumers very, very significant amounts of money by undertaking more significant amounts of money by undertaking market investigations as opposed to enforcement actions. Particularly with digital markets, it makes a lot of sense to be able to look at the markets altogether because it's the features of those markets that potentially cause problems for competition and try to essentially impose remedies or changes to the structure of the market. And this can be simple things as, for example, making it compulsory to put certain bits of information when somebody is signing online to a network and so on. Similarly, transparency seems to be a real concern. So having read these reports, transparency is, or the lack of transparency is a common feature across all of them. And the lack of transparency cannot really be good for either side or any side of that debate, I don't think. So there's lack of transparency with regard to advertising. Advertisers don't necessarily know what types of advertisement is working, what isn't working, essentially where their money is going. And there's lack of transparency in some other business-to-business aspects of these relations, in particular when it comes to platforms that intermediate transactions, sales, e-commerce between businesses and consumers. And I think there's also lack of transparency when it comes to the use of consumer data. I'm not sure consumers have been provided with sufficient information that make it transparent enough for them to understand how their data is being used. So improving on these through regulation, to me, sound like no-brainers. Now, there are two other aspects as well that I think can be improved by using regulation, but these are not as straightforward as the first two. And those relate to data portability and data interoperability. Again, it seems an obvious way of increasing competition in these markets. If there are lock-ins in these markets, and if that results from the inability to carry one's data to somewhere else, or even if you carry your data, you can't use, let's say, more than one service at the same time because there's no interoperability. I think these are fairly obvious ways of trying to make competition work better on these markets. But the sharing of data or making data interoperable also will raise first concerns in terms of, let's say, privacy and data protection, but also concerns in terms of investment and innovation. So this is not as straightforward as the first two. Again, I think merger control is in need of an update, and this can be simply through means of broadening the net so that competition authorities will be looking at more transactions that were previously slipping through the net. But again, here there are some concerns that would need to be taken into account. There likely are startups there who come up with these, let's say, new ways of doing things and innovations and so on, because they want to be, essentially they see being bought by the big tech as the way out. And this is the same, perhaps, perception of the investors who invest in these. Once this new startup succeeds, a way out, an exit strategy is being bought by the big tech. So these will have to be taken into account. But I think, again, given some thought, there are certainly ways in which regulation can enhance these aspects. So what I don't think is necessary is to essentially upend competition laws as we know them, because at least the competition law rules I'm familiar with are some of the broadest rules, as far as I know, that we have on the books. The way they're worded, they can practically catch all types of provisions depending on how you interpret them. So their flexibility, I think, here is a feature that should help competition enforcers in their application of the law. And if we actually look at the current proposed ex-ante list of blacklisted conduct that's being debated at the EU level, we see that all the examples of practices there are practices that are practically covered under existing EU competition rules. So that, of course, raises the question, why would we want to change the fundamental rules themselves if all the practices we are concerned with are already covered by those rules? Now, having said that, I think there are certain tools, which I already mentioned, that clearly need to be rethought. These include market definition. I mean, we need to find a way of defining these markets properly if we hope that the rest of the analysis will follow correctly. Same goes for market power, same goes for oligopoly competition. And I think there's a lot to be done by economists here in particular, because I think economists will have to start agreeing on some of the fundamentals here. Because if we look at the literature now, if we look at the commentary, we'll see that prominent economists still disagree on the question of even whether they're still concerned with increased levels of concentration. And they'll have to essentially find some common way of agreeing on some of the fundamentals like that, if essentially economics is going to continue to contribute to the practice of competition law and policy. Similarly, prominent economists still don't agree on how to define barriers to entry. So these are fairly basic questions, perhaps, but they are underlying some of the cases that either don't ever happen because there's disagreement on these, or that get essentially hung up on these issues. So to conclude, I think having considered really the background and the rules and the business model and the challenges, there are really no simple policy, legal, or regulatory solutions here. So these are dynamic markets, and whichever way we move, whatever the direction of travel, the responses will have to be dynamic as well. And the responses that we give will also have to be continuously reassessed in order so that they don't become irrelevant. Market investigations, as in the UK, which would facilitate the imposition of remedies to make those markets work better, seem like potentially invaluable tools that competition authorities can have if they don't currently have these rules. And having sort of said all these things competition authorities can do, I'm also fully aware that they will be restrained by capacity constraints. These actions will all need resources, and they are essentially faced with some of the largest companies on the planet. So it's also obvious to me that competition authorities will have to engage in more formal cooperation with each other. So this could be through regional networks or broader international networks, but they will have to join forces as far as I can tell. And they will have to join forces also because the companies that they are looking at are all global businesses active in practically all the countries in the world, and these need global responses. Having said that, I don't think that every problem that I have talked about today is necessarily a competition law problem. And I think it would be a useful exercise also to establish which of these are actually competition law problems or could be resolved by competition authorities. In fact, even those problems which appear like competition problems, because of this complexity of the world we're living in, are not necessarily even pure competition problems. I think particularly in the space of technology platforms, it's hard to imagine that any competition law problem will not also involve an element of data. It will involve an element of data, and it's quite likely it will also involve an element of data protection and consumer protection. And this would suggest that we also need new frameworks for these cross-policy cooperations. And as far as I know, we don't currently have these. So the Data Protection Authority does one thing itself, the Consumer Protection Authority does one thing itself, and the Competition Authority does something else. But particularly going forward in relation to digital markets, we need established frameworks for these authorities to be able to cooperate with one another and also with their international counterparts. I don't think that this requires some of the radical changes to competition law, such as introducing presumptions of illegality and reversing burden of proof, because I think for that type of change to existing frameworks, we would need to have systematic evidence that we have tried to apply the law in this case, we've tried to apply the law in that case, we have all these cases in which we tried to apply the law and it failed. I don't think we can say that, at least for the application of EU competition law. And according to one database, in the last 5 years, there have been 30 cases in the EU against platforms. So clearly, the law is capable of being enforced as it is. And therefore, I think we have to there distinguish between a failure of the law to be applicable or to achieve its aims to preserve competition on markets and a failure of perhaps enforcement of the law, because the latter would require improvements on enforcement rather than changes to the fundamental rules. So to conclude, I think since my talk was about the direction of travel, the way I see it, the direction of travel almost certainly involves a mix of market-driven solutions, and there will be some regulatory solutions, and there will be enforcement tools, existing or new enforcement tools being used by competition authorities, consumer protection authorities, and data protection authorities. Thank you.
Okay, Pinar, thank you. Yeah, thank you very much for this nice, this nice presentation. It's been very clear for me and very insightful. I think that's and it's well balanced between the two extremes. Okay, and with insightful proposals. So thank you very much for this this presentation. So now it's the time for the other people that we have in our first row to just incentivize or to motivate or to enrich the debate. So I will start with Shane, to ask her if she has any questions or if she wants to put some topics on the table. Okay, so Go ahead, Shane.
Mark, thank you. And thank you so much for inviting me to be part of this discussion. That your whole deck and that conversation is the basket of my favorite issues that I spend all my time on. So it was great to hear your perspective on that. For me, a lot of this is the ability for the markets to self-correct, and they've done that through innovation. And so I'm very concerned about regulation getting in the way of that path. But to break that down into a couple different parts, part of it is, for me, it's the consumer interest. So they have better product availability and better product, I'll say quality, but they also have the ability to take things back if they don't like what they have. And I'm going to focus just for a second on Amazon. So Amazon delivery, I think, has been the godsend, besides the ability of having internet access during COVID, just the things that have been available. So it's a little challenging for me when we have so many people that want to break it apart because it's working. So when you take the time to look at why Amazon works and why you have smaller businesses that are actually part of their process, is because they've handled two things very well. Logistics, which is always a huge part of getting your items to market, especially if it's across a country or across the pond or wherever it is that it needs to go. I was actually in Barcelona for a meeting 2 years ago, and I just wanted something, and I was talking to the Amazon lobbyist, and I go, I'm so used to just putting it on my Prime and having it come the next day. She goes, well, you can still do that, just deliver it to the hotel. And I was like, okay, I just hadn't gotten out of my mindset that Amazon only comes to my house. So the logistics have been, the ability to get so many different products, I think, is something that we need to focus on. And then the other one is and it's now no longer proprietary, but they were the first ones to use one-click. So one-click made the process so much more frictionless. I didn't have to constantly key in my delivery information or my payment information. And since that has gone off of being a proprietary algorithm in the last, I think, 2 years, we've seen other things. We've seen PayPal restructure itself to be a similar, it's one step beyond just being on the website, but I usually can go to PayPal to take care of those two things, my friction and my payment process. We have Shopify here in the United States. I don't know if you have it in Europe, but it's very similar. And it allows you to be on a separate website besides Amazon and still have that ease of capability of purchasing the item and not having to key in all that information. I can understand the reason why people think that sometimes that's too easy. I'm not allowed to order anything off Instagram between midnight and 6 a.m. because it is so easy. And I got this lipstick because of that. So the entry to the market and distribution, I think that the European Competition Authority is looking at an interesting question, which is, well, looking at one side of the question, I think it needs to be a balance. Is there harm because some of these items are being emulated into the Amazon marketplace? And are they doing that because they're using their information flow off big data to bring things to market at a lower price point? And I'm going to get back to that in just a second, because once we get past the technological tools that are built into the platform that allow for logistics and payment, you have the big data question. So that is what I call the algorithm magic. The platform knows what I like and it serves it up to me. And some people might find that too easy. I love it. I wish the rest of my life was as easy as doing things on Amazon. 80% of life is pre-decisional. If you know I'm going to want it, just make it easy for me. But there is a side note. I'll say that one of the things about big data in general is that it is a target for hackers, which brings in a couple different issues that you touched on, but one of them is privacy, and then the other one would be cybersecurity. So you need to be careful as you're building these, and this can be a challenge, especially for smaller companies who may still carry a lot of data that would be considered a privacy challenges. It's easy for hackers. Hackers go, like, it's like the old adage about why do you rob a bank? It's where the money is. You hack the data because it's there. And one of the things that we know, Amazon so far has done a great job of is not having any issues around that. I know I just got a whole slew of letters saying that my data was out by hospitals, things that I want to have trust. And I think part of what you've done in an interesting way with the GDPR is made the cost point is such a pain point on privacy / data that companies are paying more attention. And I think that could be very helpful from the consumer welfare standard of making sure that the information that you garner from these purchases is protected. And then the second part is analog versus digital competition law, or just laws in general. When I'm a huge user of Uber, and I dipped for a while at the beginning of COVID, but I feel safe with the way they're handling it, so I'm back. And I have several friends who are, they're very supportive of, let's say, labor unions, and they won't use Uber because of it. And I'm like, well, that's your choice. But the other thing is these taxi companies could also just either develop or hire somebody to create an app. I'd be just as, the friction point, once that's gone, I'll take a taxi, but you don't make it easy for me, right? So I'm going to go to what is that point. And so from that perspective, I can understand that it's important that consumers understand, the full measure of what they're doing, but you see that there's others that have just chosen not to use the innovation. And then go to a true analog perspective is, I'm going to use Costco as an example. So Costco is, an earlier adopter of almost the Amazon model, is that the logistics point was you would go to a big warehouse and then you would get a popular price point on items because they took most of the logistics travel out for you and you had that savings. But when people get upset about the one example that gets used on Amazon is this carrier that you can put in your car that apparently they think Amazon emulated it and tried to knock that guy out of the market, is, Costco's been doing a version of that for a long time. They have, and I'm not a Costco shopper, but I go with my dad and he gets excited when we go there, they have private label on multiple food items and on items like golf balls or things. So they do have a big data algorithm as well. It's a little lagging compared to the leading capability of Amazon, but a lot of people are benefiting from that algorithm because they know that there's popular items and then they bring them into their supply chain. And most of the time, that supply chain is not Costco. Costco doesn't get into the business of making golf balls. They hire someone out, and that's always the big guessing game, is who it is. Who's the current wine that everybody loves that's actually under a private label. So I think there's some interesting examples that we need to take a look at. The key thing for me, being a consumer, I think that we need to put the consumers first when it comes to any changes in the competition law, because it's very important that we don't get in the way of innovation. And you brought up multiple examples of the things that we need to make sure that competition law is looking at. And I also note that the one thing that's always challenging for me is the precautionary principle in Europe, because you're assuming some things that may not come to fruition, which could be very inhibitive in the market. So key focus for me on this overall debate is the consumer welfare. Is there actual harm? And then when we go to things like big data, is we just want transparency, not necessarily transparency and accountability. So I want to know what information is being collected. I don't necessarily need to know the secret sauce of what the algorithm is doing with it, but I'd like to know what part of my consumer information is there. And most of the big platform companies you have the ability to go look and see what data is being collected on you. And the other one is accountability. Once they have the data, how are they using it? Is that in line with current regulatory practices? And do I just have a clear understanding of what's going on with the data once it's collected? So those are the key points. And again, I just want to thank you for bringing me into this discussion. It's really interesting.
Okay, thank you, Shane. Yeah. Thibault, go ahead, please.
Sure. Can you hear me?
Yes.
Yes, great. So first of all, thanks again for the invitation. I'm afraid I'm going to be a bit annoying because I very much agree with pretty much everything that Pinar has been saying. So instead, I will just have 4 things that I want to add to the discussion. So we'll proceed in that order. The first point, and that's something that came to my mind at the beginning of the presentation, to me, it seems that one of the big issue in terms of big data and competition is, do we think that companies could eventually get rid of uncertainty because they have the data, right? We know that for now they do an okay job, but we have lots of examples where they failed to acquire a company. I mean, Yahoo failed to acquire Google, and MySpace failed to acquire Facebook for $1 million, which now seems crazy, right? So the question is it possible for them, because of big data, to have a better view? If the answer is positive, it seems to me, then we will see some anti-competitive practices there, right? Because it's actually easier to target a new company coming in on the market. If the answer is negative, it doesn't mean that we shouldn't care or do anything. I think then the very important question is, who owns the infrastructure? And if you own the infrastructure, it means that you can wait for another company to emerge and then eventually kill the company at that time. So I think, for me, thinking of it in terms of layers is very important when it comes to those ecosystems. But another question that goes along is the same question for agencies. Do we think that because of big data, agencies will be able to make a better job at two different things. The first is to tailor better decisions and policies. And if that is the case, and to some degree will be the case, but I think it will be very interesting to know exactly which data agencies need to be able to, put some better decision in. So I think it will be very interesting to hear from you maybe, and from agencies generally speaking, but also in terms of understanding markets and companies and industries. It will be interesting to know which data will be helpful there. So that was the first point. The second point I wanted to mention, and here again, I very much agree. At some point, Pinar, you said that we don't even know what a platform is when it comes to the law. I'm not even sure if we know what a platform is, generally speaking. And for me, there is a big distinction which is important between platform and aggregators. Very shortly, a platform, which is actually a French word, which comes to the word platform, which literally means a form that is flat, that you can use to build something on top of it. It seems to me that that is a platform, and that is the meaning in the Oxford Dictionary. And that, to some degree, you could argue that an operating system is a great platform, right? People can use it to build softwares on top of it. When it comes to Google.com, Amazon.com, Facebook.com, it seems to me that you cannot use them to build something on top of it. What they do is that they take data that exists already, and they combine those data, and they will give it to you in a certain way, which supposedly is convenient for you, could be convenient for them. And I think that raises two totally distinct questions when it comes to competition law, and especially, again, if we want to focus on anti-competitive practices, it offers different possibilities for those companies. So I just wanted to put that on the table. The third point, and here again, at the end, I think the first 3 points are very much related to what you stressed many times, the idea that we need more studies. I'd like to make a distinction between network effects and the learning effect. The idea of the network effect is that, and we all know that, the more people are using a service, the more you can derive from the service, right? Let's say there is a new social media, awesome features, no one is there, you cannot derive anything from it. If you publish a great video or picture or whatever, if no one sees, then there is no use. Why would you do that? The learning effect is a bit different. To some degree, they are interrelated, but the learning effect is the idea that the more people use Google or Facebook or those companies, the better they become, because they actually know your behaviors and what you are expecting from them. And to some degree, I think we've seen a true correlation between the two, because the more users, the more you can actually learn from those users. I think it would be interesting to know if, because of big data, and especially the way we analyze those data, we can actually decorrelate the two. And potentially you could argue that you could be a small startup with not really a network effect, and yet you have few data, but you can analyze those data in a better way, and therefore learn from your users and compete with tech giants, or not. But once again, I think it will be interesting to see, and indeed, when you mentioned Spotify, I think it's a great example. And we've seen Apple Music, and we were told that Apple Music will take over Spotify because they have more users and therefore more learning effect and network effect, and it's not really the case. So that's the third point that I wanted to mention. As for the fourth, it's a bit different. I wanted to come back to what you mentioned in terms of ex-ante regulation and all of the tools that we may have in the future. It seems to me that, and from a French perspective, this is something very strong, and that's the way I was raised as a lawyer, so I'm definitely biased there, but I was raised being told that the idea of the procedure is very important, and a procedure is something that will actually allow you to get to the facts and to understand what's happening. And by the way, in the US, especially in the field of competition law, we discuss all the time the School of Chicago and the Harvard School, and now the George Mason or Neil Brandeis schools of thought. There is another one that is never mentioned, which to me is very interesting, which is the School of Legal Process, School of Jurisprudence. And the idea was to say that we need case law to understand what's happening. It seems to me that we do not understand yet what's happening on digital market. It doesn't mean that we shouldn't do anything, and I've been mentioning a few areas where potentially there are practices we should tackle. But when it comes to automatizing those remedies and putting some ex-ante regulation, I fear that what we're going to try to do is just circumvent all of those decades of jurisprudence, which are, yes, burdensome for agencies and for companies, but probably there for a reason. So it's just something that I wanted to put on the table, because I think to some degree, we need to discuss whether or not, what's the role of the case law and going to the agencies and arguing instead of just regulation and having a blacklist of practices. So again, thanks a lot for the invitation, for the talk, and I look forward to the rest of the discussion.
Thank you, Thibault. Yeah, I suggest that to finish the four interventions and then we open the discussion. So Sandeep, go ahead. I'd like to see your insights.
Wonderful. Thank you so much, Mark. It's an honor to participate in today's discussion and respond to Pinar's interesting presentation. So I'll offer a couple of points. I think to begin with, it's important to really separate the technologies we're discussing, whether it's e-commerce, search, or social media, from the particular organizational forms and particular business practices. There's no one-to-one correspondence between a certain technology and a certain organizational form. And Amazon itself shows that we can have different organizational forms, for example, providing e-commerce. So if you look at Amazon's consumer-facing e-commerce business, there are at least three distinct lines of operation. First, Amazon functions as a traditional retailer, purchasing goods at wholesale and reselling them at retail. So for example, it buys Nike shoes at wholesale and then resells them on its own account. Very similar to a traditional brick and mortar retailer. Second, Amazon also sells its own private label brands. For example, Amazon Basics batteries, typically contracting with the manufacturer and selling these products under a new Amazon-specific label. And this business is not that different from discount retailers in the United States and Europe. Third, Amazon also has a marketplace where third-party sellers, which now amount to millions of sellers in the United States and elsewhere, come to Amazon and sell directly to consumers, using Amazon simply as a marketplace. This is very similar to what eBay pioneered in the late 90s and early 2000s. So I think when you dig into all these companies and these markets, we often find that the technology is new, but the practices and forms are often quite old and well established. So take the recent government case in the United States against Google. Google is not being prosecuted for making a better search engine. It's being prosecuted for really two distinct practices. First, it is accused of tying various apps together. For instance, it has told handset makers that if they want the Google Play Store where Android apps are bought and sold, they also have to pre-install Google Search and other Google apps. So this is a classic example of tying. Second, Google is accused of requiring exclusivity or inducing exclusivity from handset makers. For instance, in the case of Apple, Google is accused of paying the company around $12 billion every year to exclusively pre-install Google Search tool at the expense of Bing, DuckDuckGo, and other search engine rivals. So if you look at this case, it involves tying and exclusive dealing, practices that have been challenged for decades. And in the United States, it's actually subject to its own law, Section 3 of the Clayton Act, which restricts the use of tying and exclusive dealing by firms with market power. So the practices are old. It's the technology that seems new and novel. And I think the Google case raises important questions of fair competition. What are the practices that firms can use to gain an advantage over competitors? And I think it's useful to step back for a moment and realize and recognize that the law structures markets in general and competition in particular. There's no such thing as a free market. Every modern market is a product of extensive state-defined and enforced rules, starting with property, contract, corporate charters, but that's just an illustrative example. I think Katerina Pistor's recent book, Code of Capital, is a great resource if you really want to understand how the law structures markets. She focuses specifically on modern financial markets and how revisions in the law contributed to the 2008 financial crisis. So when we're debating competition law, competition rules, we're really debating different configurations of rules. No one is actually debating a quote unquote free or unregulated market. So at present, we have a set of rules that generally favor the interests and prerogatives of the executives and shareholders of large firms. And we could easily have another set of rules that favor the interests of workers, small firms, and consumers. And recognizing the state construction of the market, we soon realize, not all methods of competition are permissible. There are certain forms of competition that are restricted or prohibited entirely. So for example, firms cannot gain an advantage over rivals through false advertising and patent infringement. We have well-established laws on deceptive marketing and against patent infringement. So turning specifically to competition and antitrust law, it's rather vacuous to say that antitrust law protects competition. The question is, what types of competition does it protect and what types of competition does it proscribe? How should firms compete with each other? What business practices and means of obtaining advantages should the law encourage? And what practices should the law restrict or prohibit entirely? So we really need to have debates over fair competition. What are the rules of a fair marketplace? So we can have one set of rules where firms are encouraged to compete by making better products and treating customers and workers fairly. We can have another set of rules where firms compete by mergers and acquisitions and through union busting and suppression of wages. So to make this a little bit more concrete, take the example of Uber. The issue with Uber is not really the app. The app, as far as I know, based on conversations with software engineers, is a fairly trivial piece of software. The objection to Uber is it breaks laws of general applicability, such as labor and employment laws, local municipal cab rules, and also has the privilege of losing money indefinitely thanks to its backing by venture capital firms. So Uber is not being criticized for making a better service or offering something new and more convenient. The issue with Uber is that it's engaging in unfair competition by violating laws of general applicability. So Uber is functioning in many ways like an athlete who uses performance-enhancing drugs to acquire an advantage over rivals on the field. So I think we have to return to first principles, figure out what does a fair competition look like? What is a fair marketplace? What are the practices we want the law to encourage? What are the practices we want the law to discourage? And the law does this one way or the other. There are implicit notions of fairness bound up, even in existing market rules. And I think to end on a note of agreement with Pinar, I think collecting evidence is very important. We need a much more empirically oriented approach to competition law. At least in the United States over the past 40 years, law and policy has been driven heavily by simple and often simplistic theories and hypotheses. If you read court decisions, they're often driven exclusively by deductive reasoning with little engagement with how businesses function, with how customers make decisions. It's often very simple economics 101 that's driving results in court decisions and often in agency policy as well. So I think the recent explosion in empirical research around mergers and other business practices is welcome and long overdue, and really helping shake up policy and discourse in the United States. But ultimately, we do have to have the normative debate. What do fair markets look like? I think collecting evidence is important, can certainly inform debates, but policymakers and ultimately members of the public must debate and decide what constitutes fair markets and what constitutes fair competition.
Okay, thank you. Thank you, Sandeep. And Daniel, it's your turn.
Great, thanks. And thanks for the invitation. I think that was a great summary of where we're at. And a very balanced presentation of both the opportunities and the challenges that are facing the digital economy. I particularly appreciated the spectrum of potential suggestions for regulatory response. And I second, or maybe even third, the call for evidence data-driven analysis focused on improving consumer welfare through cost-benefit analysis. And I also agree, Pinar, that the push to expand competition law to become a tool for other social concerns like privacy or speech is suboptimal. Just because we have a hammer doesn't mean that every problem that we face is a nail. So just some quick additional thoughts in no particular order, and I don't think any of these are challenging what Pinar was saying as much as building on the insights that she brought. One is that digital market issues often look new, but there are old offline analogs to draw upon, right? So for example, offering consumers free products is unusual, but free is not necessarily new. Social media companies are not the first industry to figure out that you can give away a product to consumers for free and rely on advertising revenue. That was, of course, the business model for traditional radio and television broadcast. And antitrust regulators didn't hesitate to bring cases to police competition in those traditional markets. And similarly, the issue of sort of paid product placement or preferential search results, right? Strikes me as not much different than manufacturers using trade spin to buy preferential shelf space in retail stores. So these practices are sort of new twists on old models. But I think Pinar is right that digitization is making these issues far more complex. I like the way she framed the issue of ecosystem competition. And I agree that the challenge becomes, how do you determine market share or market dominance? Because it's hard to define what exactly the market is. Professor Tim Wu, who was the brain who coined the net neutrality phrase, describes social media companies as attention merchants. And I think that really kind of captures the universe of what's happening, at least in that corner of the internet ecosystem. Right? Facebook is competing against Twitter, but it's also competing against things like traditional broadcast television, because what they're trying to do is attract eyeballs, slices of the consumer's most limited, scarce resource, which is time. And that becomes really hard to measure, right? Because the competitive effects are coming not just from existing markets or adjacent markets, but also potential markets, right? Entrepreneurs who are trying to figure out how to break into that field if, in fact, the existing oligopoly makes a misstep. And that sort of specter of potential competition is really hard to measure through data-driven efforts. I think it's helpful along those lines. This is my second point, is recognizing the importance of dynamic or disruptive competition, right? I think if I were to criticize existing competition law, at least from an American perspective, which is where I'm the area I'm most familiar with, regulators too often focus on creating space to recreate a second competitor who's doing what the current subject is doing, right? So the cry, for example, to make sure there's space for a second Facebook or a new Facebook. And it creates a bias toward, in many ways, recreating the existing model. But in platforms, what we see oftentimes is dynamic, disruptive competition, right? The idea is not to create a second Facebook, but to tweak the existing model to do it better than Facebook. And that requires making space for companies to experiment. One concern that I have with regulation, particularly sort of prophylactic regulations like ex-ante rules or structural separation rules, is that they can be kind of short-sighted. They can intentionally or unintentionally lock in existing business models in ways that can limit the planes of potential competition. If you go talk to the business guys, right, they'll say it's hard to predict in advance which models are going to win. Businesses throw a lot of ideas against the wall and see what sticks. But for that to work as a competitive discipline, right, a way to discipline existing players, it becomes important to make sure that you're keeping the sandbox as open as possible for that type of experimentation and innovation. So for example, just drawing upon some telecom case studies that I'm familiar with, right? T-Mobile 6 or 7 years ago was the #4 wireless player in the United States, and a distant #4. They were never going to gain on the market leaders, Verizon and AT&T, just by offering the same thing as the market leaders and trying to do it better, because they lacked the scale and they lacked the resources to provide exactly what Verizon and AT&T offer. So they expanded the plane of competition by zero rating music, right? Saying that a consumer's choice of music wasn't going to count against their monthly data cap the way it does with the market leaders. And Orange in the UK did something similar, right, with swappables. They had content-based wireless promotions where a premium data package threw in free access to 1 or 2 services that you would otherwise subscribe to, like Sky Sports Mobile or the Times of London or the Deezer music streaming service. These partnerships were classic niche strategies, right? It was a way for smaller providers that lacked the scale to compete on price or footprint alone to be able to gain share. But that was, in a sense, right, vertical integration, taking some type of partnership or integration in order to increase the planes of competition, and in that way redefine what it meant to compete in the wireless space. And of course, those relationships can work in the other direction too, right? So last year we saw Disney Plus launch a new streaming service, and one way that it broke in a big way was through its partnership with Verizon, right? So people who bought certain Verizon packages got 1 year of Disney Plus free. That not only gave Verizon an edge on competition, a way to attract some customers away from competing wireless providers, but it also gave Disney Plus immediate built-in subscriber base that jump-started its competition with Netflix. And so when we get concerned about things like, for example, vertical integration or vertical agreements, prophylactic rules that suggest some vertical agreements are problematic and therefore we should scrutinize them very carefully could limit these types of good competition, ways that expand the way we think about what the platform is doing and what exactly the company can offer to consumers. And then finally, I want to close just by seconding the push toward digital literacy. I totally agree that informed consumers are going to be an increasingly important element of robust competition in the digital marketplace. And I think one role of regulators in aiding this is through transparency and disclosure obligations, and also aggressive enforcement of deceptive competition rules, making sure that whatever companies are saying to the public, they're in fact being held to it to make sure that it's the truth, the whole truth, and nothing but the truth. And the one caveat I would offer is the concern that too much transparency can sometimes become a tool for anti-competitive coordination. So for example, there's a case study in the United States where at least arguably the requirement that long distance companies tariffed their services became a situation where market players could coordinate their pricing strategies through the tariff itself. So the regulator became the inadvertently the manager of an unintended and legally blessed cartel, right up to the point where we de-tariffed. So I guess I'll stop there and turn it back over to discussion.
Yeah, thank you, Daniel. Well, very much, many topics on the table. So, Pinar, I mean, I have plenty of notes, or topics that we could discuss, but I don't know, Pinar, if you have any preference or something that you want to add.
No, just really to say thank you to all the comments. I think I agree with almost all of them. So bar one or two, I mean, I'm very pleased that we can find common ground, and there are lots of, I think we have raised a lot of questions. I just fear for you, Mark, that we've raised so many problems that we haven't quite raised so many solutions to those problems. And I don't know where this leaves competition authorities and, regulators. But no, I mean, I don't have anything in particular to respond to. So happy to take your comments or questions.
Yeah. Do you think among all the topics that you have put on the table, yeah, well, we have a problem, well, we have many problems, but one of all the things that you said is the thing about collaboration. I think that the practices that are taken by, well, digital markets are global markets, so this is a big problem, even or much big problem for us, which we are a very small competition authority compared to other authorities. So collaboration and cooperation, and it's much more important for us than, for example, for other big authorities. But yeah, this is a problem for us when we tackle digital markets. But apart from that, one thing that is on the table is, there's an open, there was an open consultation of the European Commission, and this open consultation about the Digital Service Package Act was mainly about the figure, the role of the gatekeeper. And one of the things that we put on the table today is, could we define what is a platform or a gatekeeper, or can we set some things, or how could we define what is a gatekeeper? Or do you have any insight for that? Do you have any idea, or how would you define a gatekeeper, what a gatekeeper is?
So I'm not sure what the right way to define a gatekeeper would be, but I think I can guess how we will end up defining them. I think we will end up defining them probably by number of users, I assume. So we might end up with a situation where we have a rule that says you are a gatekeeper if you have more than 100 million monthly users. Or, I mean, you may want to define them, of course, by virtue of the so-called gatekeeper market they're active in. But the problem then is, as we said, it's so difficult to define the market. If you can't define the market like that, how do you define, if you want to use market shares, you'll have to define the market. And then you have the issue, well, let's say a company like Amazon, is it a gatekeeper to, as Sandeep said, there are several types of Amazon businesses within the Amazon umbrella. So is Amazon a gatekeeper to the marketplace, to online retail, to retail? I mean, I think, to be honest, as I said during the talk, bundling them together as gatekeepers may not make so much sense, particularly because such a broad term can catch, let's say, so many different platforms. So the last thing I heard was that it was possible that we would end up with about 20 gatekeepers that would be official gatekeepers under the European Union's rules that it's consulting on. And it's again been in the sort of reported in the newspapers that, for example, Booking.com may be one of them, and I assume so will Google, and so will Facebook, so will Amazon. So it's all well and good to call all of these gatekeepers, but the rules we will want to impose perhaps on a search engine will be very different to the rules we may want to impose on an online booking agent, because even the way they make money is completely different. So the short answer, I think, to your question is we will probably end up with some sort of, I suppose, ultimately arbitrary rule on if you have more than so many numbers of users, or perhaps turnover. I don't think it'll end up being turnover. I think it's more going to end up being something in the range of numbers of users or numbers of transactions, let's say, facilitated by that platform. Then you will be subject to this many different rules. But I think the real issue will be, what will the content of those rules look like? Who will enforce them? How will they be enforced? And how will they interact with the existing competition rules and competition enforcers who enforce those rules? Because as I said, the content of the rules that are being debated sound very similar to the actual content of practices that would be covered under existing competition rules already. So yeah. I'm not sure what where the added value will come from if that's the direction of travel. But I'd like to hear, of course, what the discussants may think about that too.
Yeah, I don't know what the opinion of the others.
I have two thoughts on gatekeepers. One is one that actually does continue to follow the regulatory guidelines, is gatekeeping around payment processes. And this does vary country by country. But I think about how, when I mentioned earlier that the two things that have allowed Amazon to really get into the market as strong as they are is that they allow, it's a frictionless element with their payment process, but it's attached to something else. They don't run a bank. So the idea that the banks in the banking laws have stayed strong enough that you don't actually compete with them in most countries, you still have to use the regulatory process of either a credit card or whatever the banking entity is to get through that. And it's just lowering the friction barrier in that. An example of where that isn't the case, and this gets to a second one, which is free basic at Facebook, is WeChat. So, there's a certain elegance to WeChat that I really like, which I can stay in one app and I can do so many different things. I can pay for things, I can get food delivered. I mean, and it's all, but it's because there's no concept of privacy in, China. So I just know that like everything that's being collected about me is going straight to the government. And part of the benefit of that is I actually get much more frictionless processes through WeChat. And anytime we've seen somebody try to do that here in the United States, that there are regulations that kept them out of the market, which is why I think it's interesting that Facebook chose to go to India with the original free basic plan, where they were basically trying to emulate WeChat on multiple levels. And part of that was because the idea of getting on Facebook as a merchant, especially a small merchant, is plug and play. You just plug into their process and then you use a lot of their other services and the audience is already there on Facebook. That is, anybody who's tried to build a website or try to digital presence if it's not your main point of what you're trying to do, you're just trying to inform or be a marketplace, you don't want to be a web designer, any of these platforms that allow you to just kind of plug into the process. And even that's the case on kind of, Twitter is, you don't want to run an entire media program, but you can get a lot of your messages out on Twitter as somebody who's in communications. So I think that's where we saw some of the early friction when we look at free basics, even though I think they got a lot of the equation right on why it was appealing to consumers. And then going back to the regulations, that's another part of, the gatekeeping process where we still haven't seen it broke down the barriers around payment processing.
May I react?
Yes, sure.
Great. I mean, regarding your question as to what's a gatekeeper, I think once again, for me, what's important is the idea of the infrastructure, and especially when it comes, and that's what Pinar mentioned, the idea that competition might come not from a perfect substitute, right? Could you actually build another Facebook? I mean, first, what would you do that? And second, probably you cannot do that. And yet we see TikTok, which is a bit different, comes to the market and compete eventually with Facebook. But if as Facebook, you own the infrastructure that you could use to eventually get rid of TikTok, then I think it's an issue. And for instance, Amazon is a great example. Could Amazon use Amazon.com to get rid of Shopify? Probably not. However, when it comes to AWS, which is the cloud and what the infrastructure that you will need to build a service, then potentially you have an issue. So once again, I think for me, it's the idea of infrastructure. And to my distinction between platforms and aggregators, I think you will see that most of the time, a platform owns the infrastructure, and there you have some serious issues. As for the pure aggregators, I mean, if you're Netflix and you aggregate movies, can you do anything to get rid of the new Disney service? Not really. You could put some great movies, but that's pretty much all you can do. So I just wanted again to insist on that distinction, which to me seems to be very important. And I mean, again, to some degree, I understand why we've been saying platforms are big tech, because it was new and it was our way to first grasp the subject. But it's the stone age of our understanding of all that. And I think in the coming years, we'll come to some more granularity in the way we understand them.
Yeah, I'd just quickly add that I think traditional concepts like dominance and monopoly power in specific markets is still very useful. And when we're looking at particular companies, we have to look at both the downstream and upstream markets. So, a company may have multiple competitors in a downstream consumer-facing market, but it may have dominance or monopsony power with respect to upstream suppliers. So, for instance, Amazon, with respect to its third-party sellers, there's a good deal of evidence now that if a small third-party seller wants to reach a substantial fraction of the market in the United States, it has to be on Amazon. Being off Amazon often means the rapid end of that business. They just lose too much of the end-use customers to continue to survive. Whereas, for downstream purchasers, they may have more options. I think it's useful to rely on traditional concepts of product and geographic market when we're talking about dominance and monopoly. And I think that level of granularity is probably more useful than talking about gatekeepers, at least in technical antitrust debates. I think gatekeeper is perfectly fine and useful term in general discourse, but when we're talking about particular cases or making policy, we need to be a little bit more specific.
Yeah, and I actually think what I would have to say builds on that a little bit. I wonder what the utility of a phrase like gatekeeper status is, like, because we don't have a good model yet for when gatekeepers are good and when they're bad, right? So in the States, at least, we have this thing called the essential facilities doctrine, which it implies when a company controls a key input that a competitor needs in order to compete. But beyond that, it's not clear to me what work the gatekeeper metaphor is doing. And I get concerned, as I often do in tech policy, that when we lean too much on metaphors like gatekeeper or walled garden, the metaphor itself winds up doing some work that hides the complexity of what's going on, right? So to take the Epic Apple dispute right now, Epic Games is essentially challenging that Apple has is acting as a gatekeeper to Apple's consumers. And when you phrase it that way, then it becomes easier for Epic to try to define a market of iOS users, which I think hides the fact that iOS is actually competing against other platforms, other ways in which consumers access the Fortnite product that's ultimately at issue in the Epic lawsuit. And so by using gatekeeper type terminology, it may mislead the court into an unduly narrow market definition. in a way that actually distorts rather than enhances competition.
Okay, thank you, Daniel. Yeah, I would like to finish at 2:30, so we have 5 minutes ahead. Yeah, I have many questions, but maybe I would like to introduce another question or two questions. Yeah, Sandeep, when Sandeep introduced the idea of whether we have a problem with I would say, correct me if I'm wrong, but whether we have a problem with the structure of the market, or if we can make or modify the rules in order to change the structure of the market. For me, that's an interesting point. I mean, do we need more rules? Do we have to change the rules in order to make competition to act in different ways, or to enforce or to promote companies to compete in another way? Do you think that there is this need of changing the rules?
Yeah, I'll just speak about law in the United States, but I think over the past 40 years, there have been a series of reinterpretations and revisions to law that have encouraged companies to grow through mergers and acquisitions, through low-cost pricing, through exercise of dominance, that have been generally undesirable for society. I think we want companies to succeed and really thrive by making better products, investing in new technologies, investing in new processes. And the law has helped to channel business strategy away from the latter toward the former. So I think, at least here, we do need to have a wholesale reevaluation of the law. Are companies being encouraged to compete in desirable ways that expand the pie, that increase the capital stock, or are they being encouraged to compete in sort of zero-sum ways where, for example, business assets are just endlessly being swapped and bought and sold between companies instead of developing new assets, developing new productive capacity? I think one problem here is we're heavily dependent on the so-called rule of reason, where outside of horizontal collusion and other forms of cartel activity, every antitrust case involves figuring out effects, whether a particular merger is likely to have short-term adverse effects on consumers, whether a monopolistic practice adversely affected consumers over time. And instead of this very complicated, often convoluted process of trying to figure out effects in a particular case, I think we should have much simpler per se rules and presumptions that say certain practices are restricted or discouraged while other practices are tolerated and encouraged. So I think having rules on fair competition, maybe even codes on fair competition, much more like civil law jurisdictions, would be beneficial, both in terms of transparency and making clear to businesses that certain practices are valued and promoted while other practices are restricted or prescribed entirely.
Yeah, okay. So do you think that transparency is a good mechanism? No, I think that transparency for consumers, if consumers know what companies are doing with their data, if consumers know what companies are doing, well, how do they compete, is a good tool in order to promote competition. No, I think that no transparency. If I'm as a consumer, I can compare between two platforms, and if I know what they are doing with my data, is that an element that can make them compete? For if I value my privacy, and I know what companies are doing with my data, could that be a component for competition among companies? I mean, transparency is a good tool for that.
Yeah, I was actually meant to respond to this earlier. I think disclosures have a fairly limited place when it comes to informing consumers. I think there's a lot of good behavioral research showing that to the extent customers have the time and luxury of comparison shopping, they typically comparison shop on 2 or 3 relevant dimensions. They're not actually reviewing the full universe of terms when, for example, they're looking for a car or buying a new refrigerator or buying a new microwave. So consumer decision-making is unavoidably limited and circumscribed. People are not looking at whether Amazon offers better privacy than Shopify. And there's a lot of good empirical research on this. There's a study about a decade back that found that if customers actually reviewed the privacy terms of commonly used online services, they'd have to devote about 250 hours every year just to review the terms. And that's just privacy. We're not looking at all the relevant terms of service. So I don't think it's realistic to expect people to devote a significant fraction of their lives just reading standard form contracts. So instead of disclosure-based regimes, I think we should actually be regulating the substantive terms of dealing just because of rational ignorance. People don't have the time to devote to these legalistic and often jargon-heavy terms that they're presented.
I'm a big proponent of having basically emojis for the 5 things that you care about, let's say on privacy, and I've talked to the app association about this, like whatever they are, but it's sharing this, sharing that. If one of them is, I know that emoji isn't there, I back out of the deal. That would have to be the litmus test. Is it actually valued? I completely concur. I've tried reading, multiple terms of use, and it's just every time I see them, like, damn lawyers, you're making this more difficult because you're protecting your tail and not worrying about how the consumer really understands how this information's there. So if we could do some sort of simplification, which in our case in the United States, a federal law would help to understand what is being collected, how it's being used, what I can do to opt out, what if the information that's being collected is important to me, or if it isn't, I could have a better choice going into the process, but then also the ability to review it. As we see often, you agree to the 2012 terms of, let's say, Google on your Gmail, and then it morphs, and you don't necessarily review all the things that change along the way because you did that initial entry in at a certain point.
As one of those damn lawyers, right? I might chime in.
Damn lawyers.
There are offline analogs to exactly what you're describing, Shane, right? So for example, consumers in food markets are concerned about things being organic or sustainably sourced, right? And over time, we've developed codes of industry practice as to when you can and can't certify something as organic. And so that solves the problem of, I don't want to go through an entire company's supply chain before deciding whether I'm making an ethical purchase. I'm relying upon this label and what stands behind the label. So there are private ordering mechanisms that can, I think, over time get to some of those privacy concerns without having to require every consumer to read every line of terms of service. We're just not quite there yet.
That's actually engaged, to take that a little further into what could be a tech thing, is that's in their EPC code. So when you go to get organic celery versus non-organic, there is something, you might have missed that, but when you actually go to scan it in, or somebody that information is in the EPC code. So there's this ability along the way. Somebody has realized that digitizing that information is actually relative. Not that I remember the codes of all my vegetables and fruits, but I do know there's a difference, and they've actually taken the time to standardize that, which we don't have in the privacy space per se.
Okay, thank you. Thank you very much. I think that we should end the session here. So thank you very much to all of you. Thank you, Pinar, very much for your insightful presentation. Again, it was very, very, very nice. And thank you to all of you for your additional contributions. As I said before, this is the last one of our sessions, a series of presentations that we've made regarding digital markets and competition. I would like also to thank all the people at the Catalan Competition Authority who has helped us, or who have been working organizing these seminars. I would like especially thank to Xavier Puig, who is one of our technicians or people here at the Competition Authority, who has been pushing us to make these seminars and to investigate and to tackle all the topics regarding digital markets. So thank you to all the people at the Catalan Competition Authority who has helped us in order to organize these sessions. So with that, I will end the session here. I have one comment at the chat, but let me check. It's a thankful message from Shen. So thank you again to all of you, and take care.
Thank you for
Best
having
regards
us.
Thank you
and
so
best
much.
wishes and take care. Okay.
Thank
Great
you for
discussion.
having us and for joining us. Thank you. Bye.
Thank you very much.
Bye. Take care.
Bye.